For the First Perspective, I'm Trevor Greyeyes. Just before the holidays of 2012, I got a chance to speak to Bill Gallagher, a lawyer, about the Kapyong decision. For those who don't remember, in early December, a federal court ruled that the Kapyong barracks could not be sold. The suit had been filed on behalf of several Treaty One First Nations. Now, Gallagher should know a thing or two about situations like these, having been the original Treaty One negotiator for the feds back in the 90s. He also wrote a book called Resource Rulers. Gallagher starts off talking about the decision.
It is a federal court legal decision of a procedural or process type nature. It suspends the sale process of the Kapyong barracks. Yes, it does not give any indication as to who should or might have a claim on that area. It's not a claim-based piece of ruling at all. It has to do with the process and the procedures that the various parties are following with respect to potentially having being able to acquire a portion or all of that property.
Okay. You also have a background in this area too, don't you?
Well, I've got a specific interest in it because I was the federal Treaty Land Entitlement negotiator that was sent out to negotiate the settlement of treaty, I'm going to call it TLE issues, for the federal government. And I worked within the Treaty One area and a large group of more remote fly-in communities. But the hotspots were all in Treaty One. And so having gone through that process, Roseau River, Broken Head, Long Plain, Rolling River, Buffalo Point, I've always kept notes, and I have a binder series of chronological information, so I have kept up to date on all the material events that have transpired in Treaty One, including the, Stop the Rails protests or proposed protests. It turns out they didn't materialize in Treaty One, but the CN litigation that was settled on the steps of the courthouse and the pipeline litigation that actually went to court. I have all this stuff in chronological order and have written it up in a major chapter on the prairies. So Treaty One is an integral part of my book, Resource Rulers, and I use that whole experience to explain how the treaties evolved on the prairies and why it's important to keep that in focus today.
Yeah, because, and you mentioned the book, but in your book, when I look at it online, it says 150 victories, but it's gone beyond that now?
That's right. This book had to do a cutoff date at a given point. And so as of about January of this year, it would be about 150. Well, I have this all meticulously cataloged. I have this in binders and, again, in chronological order. But the Kapyong procedural victory weighs in at number 171 in terms of what I call the rise of Native empowerment, the biggest winning streak in Canadian legal history.
Okay, and just so people understand too, there's some confusion, but in a way, this is a resource victory over the Kapyong decision?
Well, the parcel of land obviously has a pretty substantial value, and so it has potential as a future site for development, whether it's a blend of residential, commercial, whatever. It's not a resource focus in the sense of a mine or a woodlot, but in terms of the potential for revenue streams and future self-generating opportunities, yes, a good piece of urban land that's intact would be a marvelous focus to have.
Okay, and this is not the first time this has happened in a municipality in Canada?
Well, I want to put a little focus on that. You talk about first time. This is where my history of a TLE negotiator might put some interesting facts into play. It was back in 1990 when Oka blew up, I'm assuming your listeners will have a pretty good handle on that. And then the Royal Commission came out in 1996, 6 years later, and it had a huge focus on land and resources. And that's the very time when I was out there as a federal negotiator, 1995 and 1996, and my task was to replicate the Saskatchewan Comprehensive TLE settlement. That went first. Manitoba was up next. And these settlements, I can attest to this fact, were of the highest priority for the Government of Canada. This was the Government of Canada's response to the Royal Commission, which was the response to the OCA set to. And, there were even special branches and offices set up across the country. Now, in Treaty One neck of the woods, one of the most interesting developments early on in the game was that Long Plain had, prior to my arrival, just prior, had challenged the transfer of Canadian Forces Base Portage-la Prairie, saying that that's available federal land. We had a serious TLE shortfall, which had yet to be settled, and they opposed it becoming the Southport Aerospace Facility. And they opposed it in a number of different manifestations, and they were a force to be reckoned with. And that was a very huge factor in trying to, find common ground to bring about a TLE settlement with respect to Long Plain. So they were stymied. The aerospace training facility went in, but I've always viewed Long Plain in particular as that old adage, fool me once, shame on you, fool me twice, shame on me. Are you following what I'm saying?
Yes, yep.
And so basically, here we have Kapyong coming up, another military base, clearly under Crown ownership. And, these First Nations are obviously out to, be wanting to have prior consideration on topping up their Treaty Land Entitlement, which is now, get this was such a huge government priority that it was a condition of settlement that the First Nations get a move on and acquire the property that they needed to top up their Treaty Land Entitlement. They weren't to sit on it, okay? They were to get going on it. The government wanted these things settled. These were deemed to be the hot spots that could blow up at any time or any corner of the country, and the government wanted to see progress on it. And so here we are 15 years later on Kapyong, and the whole thing seems to have lost all sense of urgency. Shortfall land, and I'm saying that to have them signed off, and get this, nobody's getting anything for free here. It's on a willing buyer and a willing seller basis. Nobody would be expropriated. There would be a commercial arrangements, all arm's length, and it was very clearly understood, and you can see where this would be coming from, that the First Nations wanted a heads up from the government as available Crown acreage came up. I mean, they didn't know where they were going to turn to buy their top up or their shortfall land. So when I got off the file, it was clearly understood that there would be a process in place, put in place by the implementation team that took over, that would give First Nations notice. And everybody was on side with that because that was it was such a priority, and I cannot stress that enough. And so here, what I find that dynamic has gone right out the window. There's no sense of urgency, and I just want to say, since I live here in southwestern Ontario, in May 2006. That's when the Douglas Creek Estates occupation, Henco woke up one morning to find out that they were not alone on the property. And, the Six Nations, Haudenosaunee, they asserted land reclamation rights over that property, mainly because it was the only single big block of land open that had not been developed, and they'd rather lock it up than prevent it from becoming just another subdivision.
Okay.
So, I mean, if these things aren't done with a sense of urgency, there is a certain movement in this country that will take other measures to settle these issues. And that's why the TLE process and its implementation has to be refocused and kept on schedule. And that's what this litigation over Kapyong is now feeding on itself. It's so lawyered up.
Okay.
That's a long answer, but what do you think?
That's good. Now, almost sounds like the current hockey impasse.
Well, that's right. You got a basketball guy talking to a baseball guy about our national game. I mean, I think this issue has to be taken out of the legal context. I think it's too lawyered up. And I think it has to be seen as a priority, a basis, in the spirit of the TLE need to know. I mean, First Nations, when I left the file, had insisted on being given notice of available properties. This one is a wasting asset. It's got mold and a number of other problems attaching to it, so there's no reason to delay it. It remains to be seen how the ownership would shake out. That would be, again, on a willing buyer, willing seller basis. There'd be no expropriation or anything like that. It's just a matter of realizing that First Nations have been greatly empowered by their winning streak. Out in BC, in the run-up to the Olympics, they successfully got an injunction blocking the same type of sale, Canada Lands Company, of two major downtown, an office tower and the former customs building called the Sinclair Centre on Burrard Street. These are like major edifices in downtown Vancouver. They also undid the sale of the Point Grey Golf Course to UBC. That was Crown property. So that court ordered that sale be undone. So First Nations have a successful track record of, flexing their empowerment in urban environments and urban settings. And so the native winning streak is not just out there in some far-flung corner of the province. It's arriving potentially right in downtown Winnipeg. And all I'm saying as an observer on these issues, since that was the goal to be achieved at the beginning on a priority footing, everybody should just get back on that priority footing and see how they can turn this particular parcel into a win-win situation. I can say this from my experience of going down to Roseau River, the first community meeting in years, which was a very difficult experience, and not all parties participated in it. As a federal member, I went on my own on that one. And I can say that the more frustration, the more delay, the more loitering up, the higher up the bar gets raised.
Okay.
These are very skilled negotiators. They know they have empowerment and clout, and it's in everybody's interest to recognize that and get on with business.
I don't know if you could answer this question, but it's about the duty to consult. That's never been clearly spelled out by the courts, correct? That's been sort of left for the courts for the First Nations and Crown.
No, I probably would vehemently disagree with that statement. I'm probably quite unique, and that's probably because I've done so much research on this topic and am a sole consultant practitioner.
Okay.
I maintain categorically that the Supreme Court of Canada has sufficiently defined the duty to consult in treaty law, in Aboriginal rights law, and in modern-day land claims law. All three of those templates have gone before the court and have been given exhaustive treatment. Now, there may be some fuzziness around well, what about cumulative impacts where you have 2 or 3 major projects going on in the vicinity at the same time? There may be other extenuating cases. But in terms of the, duty to consult 100,
Okay.
that has been settled. I think it's oftentimes very self-serving commentators that keep all the balls in the air, that say, once again, the court has missed an opportunity to clarify. And often these same people have been on the losing end of this phenomenal legal winning streak, and that may be one way to explain their particular experience in that court process. That's just me. That's just one person's opinion.
No, I appreciate it. Thanks for that. Because I was just wondering, I read an article by Thomas Flanagan earlier this year in the Globe and Mail, in which he says, although there is a duty to consult with the First Nations, it does give them a veto over resource projects.
Well, there is the Delgamutt case would say that only in exceptional circumstances would a First Nation have a legal veto. Now, I agree with that. That's what the courts do say. But here's what my book says. My book has a preface by Alan Cairns, who's another leading political scientist, and he maintains that the collectivity of this winning streak, the magnitude of this winning streak, is tantamount to a de facto constitutional amendment. It's as if a new sentence has been entered into the Constitution of Canada incrementally that finds its genesis in this sweep of rulings. And if he's right, then all political scientists would have to stand back and recalibrate their thinking as to what does the Constitution of Canada really say in terms of the balancing of federal, provincial, and now I come along, native empowerment, the 3 levels of government. And I basically say, as a lawyer, that that point of law that says that they don't have a legal veto, they certainly have a de facto one.
Okay.
I maintain that First Nations have demonstrated that they have the ability to thwart, block, impede resource projects that they're not on side with. And if you pick up today's National Post, there are 3 examples of that in one issue.
Yeah, I saw a number of those, yeah.
All different aspects of it. So I maintain that there is a de facto veto, and there may even well be a de facto amendment to the Canadian Constitution. So new thinking is required, and that's another way of getting people back to focus on Kapyong Barracks. We have Broken Head, which I have spent a lot of time on. I mean, it's you have to wear rubber boots out of Broken Head. A lot of that reserve will take you right into marshlands and swamp. That's where Tommy Prince is from. He fought at Kapyong. You have the Kapyong Barracks. There's a lot of synergies here where nobody should be surprised that these historical forces in Manitoba are converging at Kapyong. And, there's a potential there, a silver lining for a serious win-win outcome for all involved.
Well, I like that. Do you think the Canadian public has to be educated or come to this realization? Because when I go through the comments following these stories, a lot of people just don't seem to even know the basics of either constitutional law or First Nations rights in this country.
Well, now that's why I wrote this book.
Okay.
I wrote this book, and this sounds like a plug for the book.
Go ahead, plug it away, man.
What I'm saying is, Doug Cuthand has written a 2-page article in Saskatchewan saying that this book is a pathway for our native future. Well, I didn't write it. I mean, I appreciate that endorsement, and he's a serious thinker in these matters, and his comments have to be given due weight. But I didn't write this for something for natives to run with. I'm happy if it helps them. I wrote this for Canadians to understand how we are shortchanging ourselves economically in this country. The last 3 mines in BC have not happened, each one 10 years in the chutes, each one having gone through a complete regulatory review, each one going down over native gaffes, that's GAFFES, gaffes and missteps. And so we are systematically handicapping our ability to maximize the potential of our resources sector. North of the Trans-Canada, I maintain that we have been historically absentee landlords, and this native winning streak has been filling that vacuum. And I call First Nations resource rulers because they have racked up such an impressive culmination of legal victories in all facets out in the remote parts of Canada, but also right in downtown major centers, that they are rulers and they are dictating, they're determining the balance of power on the outcomes. And that's the other way for doubters or critics to look at Kapyong. If you want to get on with it, if you want these things settled, cut a deal, because the more it's lawyered up, the more that'll benefit the applicants who have long-standing issues and strategies that they are prepared to take their time to play.
You know, I just want to ask you one last question here, and I think this is an important question too, because I'm putting myself in sort of the mindset of those commenters who don't quite realize it. But I know there'll be some critics out there who will say that you're just another lawyer who's trying to get on the good side of First Nations so you could get in on some of the multi-million-dollar lawsuits that are occurring across this country. What would you say to somebody who would level a criticism like that against you?
Well, that train has gone by for me. I'm 63. I have never acted for First Nations. I've acted for major corporations on some of the most protracted and difficult resource conflicts in this country, namely Voisey's Bay, where I was part of the strategic team for INCO. No, I'm not looking to spend my life on these types of issues, but I do believe that for the Canadian public, if they want to have an informed understanding of why their economy is chugging along when it should be just percolating, why it's faltering, they should pick up a copy of Resource Rulers and find out that we are handicapping the resources sector of this country in every province in a unique manner, and the common denominator is our inability to productively and constructively dialogue with First Nations. There are exceptions, but at the moment, there aren't many of them.
All right, and I'd just like to thank you for talking to us. This is Bill Gallagher. He put out a book called Resource Rulers. Where can I pick up that book?